38, the people of the state of New York versus Cesar Garcia. Good afternoon, counsel.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent appellant Cesar Garcia. May I reserve 3 minutes for rebuttal, please?
You may, sir. 3 minutes.
Thank you. The people contend that the preservation rule does not apply here because they are not the party claiming error on appeal. But this court has repeatedly required the people to preserve arguments even when they are respondent in this court. It's the people's contention that they did not need to challenge Mr. Garcia's claim in his written motion papers that a conviction for any of the offenses would make him deportable because now they are respondent on appeal. But as I said, this court has repeatedly required preservation from the people even when they're respondent.
But counsel, don't we have to apply? So when the case was in the trial court, Suazo hadn't been decided yet. And by the time they got up to the appellate division, it had. So didn't Suazo then have to be applied to the case with however the record was before the appellate division at that time?
Well, this court has never looked at preservation that way, and the people complain of an unfairness to them. That unfairness would be just flipped to Mr. Suazo if that were required. Mr. Garcia here was in no better position to anticipate the court's ruling, which required the people to make, the defendant to make a threshold showing.
That's an important point there, but it works both ways because it seems that Mr. Garcia said very, very little about his right to a jury trial vis-a-vis federal immigration law and what the requirements are for crimes involving moral turpitude and single scheme and, and all the things that we're now talking about. So couldn't that go against him in terms of whether he met his burden? As we said in Suazo, it is his burden to establish his right to a jury trial in the first place?
No, I think it was incumbent upon the people to challenge his statement that Mr. Garcia is a non-citizen for whom conviction on any of the charged B misdemeanors would result in deportability, and then he cites a statute and cases. It's no different than...
So it's your position that the defendant meets that burden just by simply making a blanket statement, any of these charges would render me subject to deportation?
Yes, just as in the standing cases that I cited, Stith and Hunter, where a defendant alleges standing, doesn't prove it, then is denied a hearing on other grounds. And the people on appeal try to say that, wait a minute, he should never have, they want to re-argue the standing issue when maybe the defendant didn't even say anything about standing. It wasn't even raised in the court below.
But I thought here you were arguing that he did more than make a blanket assertion.
That's correct. What I'm saying is this is even a stronger...
No, but just to be, yes, what you said he cited to the federal statutes and case law. So it's not like the people didn't have some idea of what was the basis of the argument.
Absolutely.
Apparently the court understood the issue very well.
And the court denied it solely on the basis that immigration consequences didn't matter for Sixth Amendment purposes.
Counsel, is that different than Suazo? This case seems very similar to me to Suazo because the argument was made, as you say, by defense counsel. It was preserved by defense counsel. And it's on direct appeal. It's a constitutional rule. And we look at it, and in Suazo, it seems to me this court addressed that issue. Was there a difference in the record in Suazo that made that reviewable by us, the deportability issue, as opposed to this case?
That's a good question, Your Honor. There's no difference in the record. And I would say that the court did address the deportability information in Suazo, but as a function of showing its work, essentially saying, defendant not only said he would be deportable here, but it appears that he was in fact deportable or could have been
And
deportable.
why wouldn't we do that here?
Because the law precludes that, that being a basis, that decision is unreviewable. So essentially what I'm saying, in Suazo, when this court addressed the facts about what made Suazo deportable, it was essentially dicta. The court was making a bold decision in Suazo and wanted to legitimize that decision by showing its work.
Are you saying that we can, over here, sorry, are you saying that we can review it for the purpose of reversing a conviction, but not for the purpose of affirming one? That is sort of a LaFontaine issue.
Well, I think there are two separate issues here. There's the preservation issue, which is more basic than the LaFontaine issue. The LaFontaine issue, they only matter because of the remedy. If it's not preserved, then the remedy is the conviction gets reversed. If it's solely a LaFontaine error, then it can go back to the criminal court to review that issue.
So is there a LaFontaine problem here?
There is both a preservation and a LaFontaine problem here.
And outline for us how you see the LaFontaine problem.
Well, the LaFontaine bars this court from reaching an issue that was not decided by the court below. So the issue here that was not decided by the court below was whether, in fact, Mr. Garcia was deportable. So
It seems to me, in Suazo, we did cite to LaFontaine but in a footnote, I think, but only for the issue of whether the defendant actually was subject to deportation anyway or something like that, not for whether what he would be convicted of was a deportable offense. What's the difference there? Why would we apply LaFontaine to was he deportable anyway, and not, it seems we were distinguishing that on as a LaFontaine basis from the issue of were these crimes deportable offenses, which we addressed.
well, Your Honor, if I recall the footnote to which you're referring, the court pointed out that that information was not even before the court when it rendered its decision, that it wasn't until after the trial that the issue about whether Mr. Suazo was already deportable came up, so that, there's a factual distinction there. Am I 100% persuaded that the court should have essentially reached the deportability grounds in Suazo? I don't think it was necessary for it to reach those grounds. That issue is not joined in the opinion. The opinion doesn't say, even though this issue is unpreserved or subject to LaFontaine, we're going to reach it anyway. So I don't think that that Suazo can be read to dismiss the preservation in LaFontaine.
Does the fact that, I had thought that the defendant here had already had an order of removal entered against him. Is that true? Was there an order of removal that predated this conviction?
That's one of the problems with the lack of preservation here, is there's nothing in the record, the appellate record before this court, there's nothing in the record before the court below to address that.
I had thought that there was an order of removal that predated it by 2 years.
Well, if there was, it was not brought to the attention of the court below, so it's not actually part of the record.
Well, the question, I suppose, for us would be, is it in the record, right?
And I would say that if it was not before the court below, when it made its decision.
It's in the respondent's brief at 5 at note 4 and the defendant's appellant's brief at, that's you at 2, note 2.
Right, and I addressed it because the people raised it, but that doesn't make it part of the record. That's the problem with failing to preserve the issue is, had it been properly preserved, these issues could have all been fleshed out, addressed.
Okay, no, I have your thanks. I
Thank you.
understand what you're saying. Okay.
Thank you, counsel. Counsel?
Thank you, Chief Judge. My name is David Cohn, and I represent the people. Good afternoon. We are asking this court to apply the exact same template to this case that it applied in Suazo.
So what was lacking in the motion? In the motion for the right to a jury trial?
What was lacking in the
Yes,
defense
what
motion?
else did the defendant, in your opinion, what else did the defendant have to present?
Well,
He said
Your
he
Honor,
cited cases, he cited the federal statute, he made the assertion. What do you say is missing?
right. Well, Your Honor, there are some aspects of the current appellant claim that are unpreserved. For instance, the argument that public lewdness is a crime involving moral turpitude. That argument is unpreserved for this court's review. In the motion for a jury trial, the defendant cited 2 federal cases, but they dealt with the other charges, the forcible touching and the sexual abuse charges, of which the defendant was ultimately acquitted, so those charges are out of the case now. There was no argument made below that public lewdness, the only crime of which he stands convicted, was a crime involving moral turpitude. In addition, the defense motion for a jury trial did not address the notion that you must have a conviction of 2 crimes involving moral turpitude if they're misdemeanors in order for them to be deportable.
Why didn't the ADA point that out in opposition?
Well, Your Honor, if we look at the way this case unfolded in the trial
And the
court,
ADA point out, look, the citations, the argument that he's relying on is made in those cases, or looking at the statutory language, don't support the motion. Why didn't the ADA say that?
Your Honor, of course, I don't know what was in the ADA's mind, but I think from the record, what we can glean is that the court had made clear that it was going to just deny this motion summarily in accordance with this court's prior precedent and the standard practice throughout the
Yes, I
state.
understand that. You have a series of arguments, and the ADA relies on one, the court is ruling on one, even though indicating if the law was different, you would have a claim, right?
Right. So Your Honor,
So why isn't that like a typical, as he's arguing, preservation issue? You had lots of arguments you could have made, you only made a particular argument, you're foreclosed from now making the other ones.
well, Your Honor, this court has never applied the preservation rule to a respondent in order to say that the respondent was required to anticipate a change in the law. All of the cases that the defendant cites, those are arguments that the respondent absolutely could have made based on existing law. And in fact, most of the cases that the defendant cites about preservation being applied to the respondent are about factual matters that should have been raised to the court by the people below. By the way, there is...
So you're saying there was no hint that the issue was percolating below?
There was no hint that the trial judge was even considering that he would grant this motion, and the judge, in fact, didn't ask the people to submit written papers. The defense submitted written papers. The trial judge only asked the people to make a short oral argument, and at that point, that was signaling to the ADA, just make your quick argument, and I'm going to deny the motion.
But wouldn't, I thought the people had conceded that Suazo was retroactive.
The people concede that Suazo applies retroactively
Okay,
to
so
this case.
let me just stop you then.
Yes.
If that's conceded, then really, shouldn't we be about the business of clarifying if the right to a jury trial rests on the potential penalty of deportation or a conviction that it resolves itself in deportation? And then we have to clarify the difference between charges versus conviction.
Your Honor, I agree that this court needs to address the merits of the claim that the
So if
defendant
we
was...
address the merits, then we're in essence conceding that Suazo is retroactive.
It applies retroactively to cases that were pending on direct appeal at the time of the decision. That is the law, and we can see that that is the law. The defense argument is that this court can't even get there, can't even engage...
But counsel, before you get to that, I think if I'm understanding Judge Fahey's other part of his question is, when we're looking back and applying Suazo retroactively, and we say, okay, here's the decision point for are you entitled to a jury or not, it's based on the charges at the time, not based on a retroactive look at he was only convicted of one thing,
Okay.
right?
Oh, so, Your Honor, perhaps I misunderstood the question. So there is the issue of when we're on appeal, do we look at the charges of which the defendant was convicted, or do we look at the charges that were pending at the time of the motion for a jury trial? Now, this court has not addressed that question. Lower courts in this state have uniformly said that once a defendant has been acquitted of a charge, that's out of the case.
Well, I think arguably there's 2 questions here. Okay, one is, was it error based on what existed before the trial in denying him a jury trial? And the other is, let's assume that it was error. And now, here we are today, but the charges that everybody, not everybody agrees, but are more easily identified as being, rendering somebody deportable. Those are the two on which he was acquitted. So now we're looking back and we're saying, okay, it was error to deny the jury trial, but here we are. What's the remedy, okay? And you know, can we apply harmless error or mootness? So, you know, because arguably we can't give him a jury trial now, but I think we prefer not to render him remediless, right?
Well, Your Honor, I think other courts have looked at this as either a harmless error or a mootness type analysis.
But where does the authority to apply harmless error analysis to this particular scenario come from?
Well, Your Honor,
or would we be deciding it in the first instance?
there are other cases, other lower court cases that have applied harmless error in this context. It would be an issue of first impression for this court. But there are 3 appellate term cases that we cited in our brief where the defendant would have been entitled, was actually given a jury, would have been entitled to a bench trial, was wrongly denied a jury trial on other charges of which he was ultimately acquitted. And then the appellate term said in those cases, because the only remaining charge of which he was convicted was a petty offense for which a jury trial would not be required, that any error was harmless because the only remedy that he would be entitled to would be a new bench trial. And it
Well, wait a
doesn't.
minute, why is that true? I mean, look, if under Suazo, he would have been entitled to a jury trial, that's what you're trying to remedy. The fact that he's acquitted of the others doesn't matter. The point is he would have had the opportunity to try and persuade a jury, not a judge, to acquit him.
Well, Your Honor, I think the distinction.
That's what you're trying to remedy.
Yeah.
So how can it possibly be harmless?
So, Judge Rivera, I think that this distinction is that in this case, to the extent that the defendant might have been entitled under the CPL to a jury trial on the public lewdness charge, that's not a constitutional right to a jury trial. That's purely a derivative statutory right to a jury trial, which was the legislature saying, because of judicial economy or because we think it would just be a very unusual
Well,
setup.
your analysis renders Suazo almost meaningless.
No, Your Honor, because if it would just say that the constitutional right to a jury trial doesn't mean that a defendant who's convicted of a petty offense gets a windfall because of some other offense that happened to be in the case where they were ultimately acquitted of that charge. What we're saying.
I don't know that it's a windfall when you're trying to comply with what the court in Suazo says he's entitled to.
Right. Well, Your Honor, please forgive me if I'm wrong, but I believe this court in Suazo was concerned about the constitutional right to a jury trial.
Yes, no, I understand that.
The Sixth Amendment right to a jury trial. And I think everyone here agrees that if public lewdness.
Yes, but as a consequence, that meant that all the charges, right? All the charges,
Right.
even the ones that would not have otherwise gotten you the jury trial right, are now subject to that coverage.
Under the CPL, so there would be a statutory right to a jury trial on the public lewdness
Well, of
charge.
course, in Suazo, we could have said you're only entitled to a jury trial right on some of the counts, not the other ones, but we didn't say that,
Well,
because that's what the CPL requires.
You're on the right, a statutory right, but there was no violation. If public lewdness is not a crime involving moral turpitude, there was no violation of the defendant's Sixth Amendment right to a jury trial in this case. So what we are arguing.
Well, that's only true if he were tried solely on the public lewdness charge, no? That is, let me try it this way. If he'd been tried for the case that the people presented, which was on all the charges, he would have been entitled to a jury, yes?
Right, Your Honor.
Right. So if that's the case, is there some chance that the jury might have acquitted him on everything?
There might be. I mean, you never know what a jury would have done. Obviously, we believe the proof was very strong in this case, but
In this
what I'm saying.
circumstance, when someone is convicted of a crime, has served the time, and all that's, you can't retry him on the charges he was acquitted of, Don't we ordinarily just dismiss the accusatory instrument?
Well, not, Your Honor, if it's a charge that, those are only for petty offenses where this court believes that it's not in the public interest to subject the defendant to a new
I
trial.
thought your whole argument was this lewdness charge was a petty offense.
It was not a serious offense for Sixth Amendment purposes. We are arguing that. But it was the type of conduct we certainly think the state has an interest in prosecuting, and we would want to proceed with a new trial if there...
Well, he's been deported.
Right, that's...
I mean,
well,
you're not going to be able
there
to
is-
do that.
Yeah, well, that is another issue,
That's
Your
the
Honor.
wrinkle
That's
in the
correct.
case, another wrinkle
Yeah,
in the case,
that-
of course.
That's correct, Your Honor.
So Judge Rivera's point, and, I mean, isn't there really a point in favor of mootness rather than any other remedy at this point?
Yes, Your Honor, it could be, in our view, either mootness or harmless error. And if you look at the cases cited in our brief, suppose, for instance,
The
there's...
reason I ask is because harmless error, I think, is a more difficult analysis than mootness may be in this situation. That's why I'm asking you the question.
Right. No, I understand. It might be simpler and cleaner to say mootness as opposed to harmless error. Your Honor, as an analogy...
How is it moot if indeed it might foreclose him from trying to lawfully re-enter the United States? That conviction. Because he has no other criminal history.
Well, Your Honor, I'm not sure that was discussed on the record, so I'm not sure that I know the answer to that question, given the
That's fair.
state of the record. If I may, by analogy, this court has in other cases said, like for instance, let's say there is evidence admitted that relates only to one of two crimes at trial. The defendant is acquitted of that crime. He's convicted of another crime. And on appeal, argues that the admission of that evidence was improper. This court, in those types of cases, and appellate courts throughout the state, will say that that error was harmless because it had no effect on the conviction of the separate count.
Yeah, but of course, here you're arguing that all of these things are part of a single scheme, so your analogy doesn't work given what you're arguing.
Well, Your Honor, that's not a different question from the guilt or innocence determination. That's an immigration question for, are these so related, and that the fact that the defendant was convicted of multiple counts, and the argument is that if he was convicted of all 5 counts, still there would only be one crime involving moral turpitude under the federal immigration law, because this was a 30-minute incident where the defendant was continuously fulfilling his sexual gratification by performing a lewd act on the subway platform, immediately following women into a train, looping around, going back. It's a very cabined 30-minute incident. The cases cited by the defense involve situations that happen as a matter of hours or even a matter over a period of years. So this is different. This is, even under the more restrictive BIA interpretation of scheme, we believe this is only a single
The
scheme.
problem is, just to add more complexity to what you would think would be a straightforward case. The way I see it is you got arguably 3 separate acts: a station platform, one train, and then a different train. I don't know the answer sometimes, but it does seem to me that it doesn't lend itself to an easy analysis.
Right.
Yeah.
No, Your Honor, and Congress used the word scheme instead of act or crime, and I believe that is relevant. I would also say that given that this court changed the law in Suazo during the pendency of this particular appeal, if this court believes that the record and arguments below were not sufficiently developed and more development was necessary, then the proper remedy would be a limited remand for the purpose of fully fleshing out the immigration issue, rather than giving the defendant a default judgment for the fact that the court and the people did not anticipate the change in the law, which we believe in all fairness is not the proper remedy.
Thank you, counsel.
Thank you.
Zeno?
Why why hasn't he got a compelling point, in this last argument that he's made, to just send it back for further record development?
So,
Is it possible to decide this without record development?
well, it's possible to preserve, it's possible to decide this case on preservation grounds, which are the clear grounds here. The remedy for an unpreserved claim has always been in this court that you don't consider it. You don't send it back for a fact-finding hearing. In Wardius v. Oregon, the Supreme Court said reciprocity is a fundamental ingredient of due process. So why do the people get a second bite?
So if we disagree on that, then why isn't he right about this last point?
If we disagree
On the
about
preservation.
preservation,
Yes.
then the record,
Disagree
as
with
Judge
you about
Fahey
the
observed,
preservation.
there are a lot of layers to this. The record is sufficient, based on what we have now, to show that my client faced the possibility of deportation because of the 3 separate occurrences, as Judge Fahey pointed out, the subway platform, the downtown train, the uptown train, 3 crimes involving moral turpitude that made him deportable. The
Well,
record
if
is
the public lewdness doesn't fit within what the BIA or the federal statute would otherwise deem an offense, let's just say it this way, a deportable offense, right? That leaves you then the other 2, and I think there's a real argument for why the public lewdness is different from the other 2.
the public
The other
lewdness
2,
is
then, he has a stronger argument that might very well fall in if we defer to the BIA, to what the BIA would construe as these acts, right?
if I think I understand your question correctly,
As a single scheme.
this single transaction or occurrence.
Yes,
I
yes.
think the BIA is very clear that those were 3 completed crimes, the platform, this downtown train and the uptown train. They were each completed once he walked off the train and waited around and got on another train. The BIA, which is entitled to their Chevron deference, makes it very clear that those are separate completed crimes when each one of them is completed. So to get back to the answer to your original question, there is enough on this record, even if we were to reach it, to find that he was entitled to a jury trial. If I could just quickly address the next question, and that is, assuming he was entitled to a jury trial, is it appropriate to give him one now or to dismiss the case for the failure to afford him the jury trial to which he was entitled? And I think that there are 2 reasons that he's entitled to that. The first is as a remedy for the 6th Amendment violation. It's clear if he was entitled to a jury trial on one, he was entitled to a jury trial on all, and that is an extremely important right to him. Evidence of that is the vigorousness with which he sought the jury trial and the vigorousness with which the prosecution tries to rebut the right to a jury trial. Having a claim decided by a jury rather than a judge is an extremely significant right, and there should be a remedy for it. But even putting that aside, CPL 34040 sub 3 says that if you're entitled to a jury trial on one charge in a single information, you're entitled to a jury trial on all of them. And the people cite cases where multiple informations were charged. That's not the case here. It's a single information. He was entitled to a jury trial on all of the charges joined together, and he's entitled to a remedy under the CPL or the
He's
Constitution.
been deported, how are you going to have a jury trial?
Can you repeat
He's
that?
been deported.
He's been deported, so therefore the remedy we ask for is dismissal rather than that right. He's entitled to a remedy. It's not moot. He has that conviction on his record permanently, whether he's in Mexico, whether he ultimately returns to the United States. To say that it's moot when there's this criminal conviction on your record, there's just no basis for that argument.
Thank you, counsel.
Thank you.